Having day-to-day issues with a particular employee? Has a working relationship with a specific individual become sour? Have you tried many disciplinary measures and are now at the point of termination? Now you're wondering, do you owe termination pay, severance, or notice? Sit tight and prepare yourself to get busy. Hello, my name is Nouhaila Azaou, bilingual business advisor with the Canadian Federation of Independent Business, and I can assure you that these are all very valid questions to have surrounding employee discipline and termination. Firing an employee can be a really uncomfortable thing to do. However, if there is no other recourse, you owe it to yourself, your customers, your employees, and your bottom line. Our advisors have coached many business owners that have faced the same problem. With employees unquestionably being the most important part of a business's frontline and backline operation, it is imperative that the relationship between the employee and the business itself be a harmonious one. Getting to the point of disciplinary action can oftentimes get a little confusing. Knowing where to begin and what proper measures to take can help you set a foundational structure to progressive discipline in your workplace. Many organizations actually implement a verbal and written warning system. Please note, you can establish however many you want. However, it is recommended as a best practice that you document even the verbal warnings. Having a rule of thumb such as 3 strikes and you're out can be a highly effective practice. Now, when you write up an employee, you should identify the policy that outlines expected behavior, the behavior that was inappropriate by the employee, and if there will be any consequences. Please note that you can also opt to suspend an employee, and in fact, this could help you to investigate and find solutions to a situation. Now, depending on whether the suspension is with pay or not is completely dependent on company policy and other factors. Nonetheless, a huge part of employee discipline revolves around your current policies. With any policy, you want to ensure that it is well publicized internally and fairly applied to all staff. Once a year, you may want to review your policies with your staff. You could do this within your health and safety meeting, remind them of the policies, ask them to sign them, date them as proof of compliance, and lastly, make sure they are available and easy for reference in the office. To summarize, simple yet effective steps such as the following could be applied to ensure all proper measures have been taken before you get to the point of termination. Firstly, never surprise your employees. Businesses that keep an open and ongoing communication with their staff are better equipped to prevent complaints and address them before they are formalized. Secondly, be clear about your expectations. Clearly establish and lead by example when it comes to conduct, respect, and professionalism. Thirdly, put it in writing. Clearly written and posted internal policies are very helpful, and in the event of a misunderstanding or legal proceeding, it may be well in your advantage. Lastly, train, coach, and mentor. The rules are clear. Employers cannot discipline or terminate employees who did not know that their behavior was unacceptable. Sounds basic, but the concept is called condonation, and employers are responsible for making sure that the employees understand and know what is expected of them and how to do it prior to being disciplined. Now that you've tried all of that and you're still in this situation, you have an employee that refuses to change their behavior, it's natural to think about termination. With termination being a rather sour part of a business's proceedings, it is inherently essential to ensure the harmony between employees, management, and sometimes even the customers. It's important to note that terminations could fall under 2 windows, with cause or without cause. Terminations with cause require extreme misconduct, willful neglect, or any action causing extreme harm to a business. Terminating an employee with cause means that you are not entitled to anything, no notice, no termination pay, and no severance. However, terminating with cause is often extremely hard to prove and possesses a greater risk for business owners. Of course, terminations are never risk-free, but there are ways to minimize the risk. For this reason, CFIB does not recommend giving a reason for termination, meaning we do not recommend terminating for cause. Any reason you give, whether in written or verbal, can increase the risk of exposure, as these reasons can be argued as unfair dismissal. Keep in mind, if you terminate without cause, you will either have to give A, notice, B, pay in lieu, or C, a combination of both. The amount of this notice or pay in lieu is dependent on the employee's uninterrupted years of service to your business. For assistance in determining how much notice or pay you owe an employee in question, please contact our business resources team that is well equipped with tools that will help you make sure that your termination process is on the right track. Well, there you have it, folks. Remember to contact our business advisors for further guidance on progressive discipline and termination. Our templates are actually available in French and in English, are easy to follow, and are simple to implement. Thank you for watching, and we hope we get busy real soon.
Hi, I'm Beatrix Abdulaziz, Policy Analyst at CFIB. Please like and subscribe to stay up to date on our initiatives, and consider joining us at CFIB.ca to see why we're in business for your business.